In boat crash trial proceedings, defense witness is cross-examined. Further persons included in today's trial are the defendant, George Pino, the victim, Luciana Fernandez, Ceci Pino, George Pino's daughter, injured survivor Katerina Quigg, second defense witness Natalia Reed, and defense attorney Laura Adams.
No.
Did you feel a little buzzed?
At the maximum, but I did not feel impaired.
Okay, but buzzed, right? Happy, correct?
Yes, yes.
Okay, gotcha. So now you'd agree that maybe people that are buzzed from alcohol are not the best judges of whether somebody else is also buzzed from alcohol, right?
Yes.
She admitted it on the stand. She was buzzed. She was not watching George Pino. She trusted him completely. And from seat number 12, facing the back of the boat, she could not see what was ahead of them, even if she had wanted to. The defense attorney paused. Then came the question nobody in that courtroom expected. From your position on that boat, was there anything anybody was doing that made it impossible for the defendant to see what was in front of him? She answered, no. That single word landed without echo. Nobody moved.
Do you remember the, let's say, 5-10 seconds prior to when that crash happened?
I would say 10 seconds before, yes.
And tell us exactly what you were doing then.
I was singing with my friends.
Okay. Did anybody stand up?
No.
In those last 10 seconds, were people holding up their hands to block the defendant's view?
People were waving their hands as they were singing. I'm not exactly sure if they were directly above, but I don't believe so.
Okay. So, from your vantage point, there was nothing anybody was doing at the front of that boat that would have made it impossible
No.
for the defendant to see what's in front of him, right?
No.
Okay, thank you very much. Oh, wait, actually, I did want to ask.
By the end of this video, you will understand exactly what the prosecution needed to prove convict George Pino of a felony, and precisely where the witness testimony fell short of that standard. On September 4, 2022, near Ocean Reef in Miami-Dade County, Florida, a boating accident occurred during a return trip from Billy's Point Sandbar, resulting in the death of 17-year-old Luciana Fernandez. George Pino, the boat's operator, was subsequently charged with felony boating under the influence manslaughter under Florida Statute 32735. The case proceeded to jury trial in Miami-Dade County Circuit Court. Defense attorney Laura Adams represented the prosecution in cross-examination of two eyewitnesses called by the defense. A Clemson University student identified in the record and Natalia Reed, a Brown University student interning in New York City. The presiding judge's name is not stated in the available record.
Are you in school?
Yes.
What school do you go to?
I go to Clemson University.
What are you studying?
I'm studying language and international health.
When do you graduate?
I graduate in May of 2027.
Do you know the Pino family?
Yes, I do.
Can you tell us how you know the Pino family?
Yes, I've known the Pino family my whole life. My mom is cousins with Ceci George's.
Do you know or did you know Miss Lucy Fernandez?
Yes, I've also known Lucy my whole life.
How did you know Miss Fernandez?
We went to school together since we were 4 years old at Epiphany.
And before September of 2022, did you know Katerina Quigg?
Yes.
Can you tell us how you knew Miss Quigg?
Yes, Kathy was also one of my closest friends. We also started Epiphany together when we were 4 years old.
Are you still friends?
Yes.
Were you at Ocean Reef with the Pinos the weekend of September 4th?
George Pino was a man his daughter's friends had trusted their whole lives. He had taken these girls on his boat before. Not once, not twice, but enough times that the speed on September 4th felt like every other trip. He was a father celebrating his daughter, Ceci's 18th birthday with a weekend at Ocean Reef. He was not a stranger behind the wheel.
2022?
Yes.
What were you doing in Ocean Reef that weekend?
That weekend we were celebrating Ceci's 18th birthday.
Were you on a boat on September 4th, 2022?
Yes.
Were you involved in a boating accident that day?
Yes.
Before the accident, were you at a sandbar?
Yes.
Do you remember the name of the sandbar?
I don't remember.
Do you know how you arrived at the sandbar?
By boat.
Who was driving the boat?
George.
So, when you were at the sandbar that day, can you tell us who else was there with you?
Yes. There was 10 girls on the boat, I believe. And
He was the person the girls had assumed would get them home safely. When the crash happened and blood poured from his head and he lay motionless between the console and the hole, his daughter's friends thought he was dead. Whatever the criminal charges say about that afternoon, George Pino entered that day as a trusted family friend and emerged from it facing a felony prosecution whose legal and financial costs, attorney fees, lost time, public accusation are carried by a real person whose name is now permanently attached to a criminal case file.
What happened after the accident, after the impact?
I just remember opening my eyes after the impact and seeing a lot of white. And the first thing I saw when I opened my eyes was George, and I thought he was dead. I just saw a lot of blood gushing, and then my friends were telling me that I had to get out of the boat. By the time I was going to get off the boat, it was kind of almost flipped. So instead of jumping from the boat, I practically stepped into the water because of how tilted it was. And then I honestly don't remember much. I just swam, and I swam to where Ceci was with Gati, and I tried to help her keep her afloat. And then at that point we saw the rescue boat, and I was just helping wave them down until they were nice enough to help get Gati onto that boat.
Okay, so a moment ago you mentioned that you thought Mr. Pino was dead. This was after the impact. Can you tell us why you thought that? How did he look to you?
Yes, I just thought that because there was a lot of blood.
The prosecution's theory was direct. George Pino operated a vessel under the influence of alcohol on September 4, 2022, and as a result of that impairment, Luciana Fernandez died. The state called witnesses who testified that alcoholic beverages were present on the Pino boat, seltzers and beer supplied in a cooler, and that those drinks were consumed by underage passengers, including witnesses who admitted to feeling buzzed by the time the boat left the sandbar. The state elicited testimony establishing that none of the girls were wearing life jackets, that music was playing loudly enough to be heard over the engine, and that the boat ride preceding the crash felt unremarkable. Nothing out of the ordinary, until the impact came without warning. Two defense witnesses testified in direct examination that they did not see George Pino holding an alcoholic beverage at the sandbar, neither had a conversation with him there, neither observed him behave in a manner suggesting intoxication or impairment. Both described the boat ride back from Billy's Point as normal in every respect: standard speed, clear skies, flat water. Nothing alarming about the way the boat was being handled in the minutes before the crash.
Mr. Pino on this boat as well?
Yes.
Did he seem intoxicated in any way?
No.
Did he seem impaired in any way?
No.
So this accident, did it happen on the way back from Billy's Point back to Ocean Reef?
Yes.
Where were you sitting on the boat, if you remember?
I was sitting towards the front of the boat.
And so during the boat ride back from Billy's point, can you describe how that boat ride felt?
It felt like nothing out of the ordinary. We were, again, just all really happy and enjoying our time together.
How did the speed of the boat feel to you?
Nothing out of the ordinary.
Did you ever tell Mr. and Mrs. Pino to slow down or to change the way that they were operating the boat?
No.
And prior to the accident, had you been on a boat before?
Yes.
Do you recall how many times, more or less? I know it's hard to tell, but if you can describe for us how many times you've been on a boat before.
I would consider myself a pretty experienced boater. My family never owned a boat, but I had gone on boats with my friends my whole life.
Had you been on a boat with Mr. Pino before?
Yes.
And this boat ride on September 4th, prior to the accident, did it feel any different than any other boat ride you've taken in your life?
No.
Most people watching this hearing missed what just happened when the prosecution asked each witness whether people who are buzzed are reliable judges of whether someone else is also buzzed. Both witnesses conceded the point. That concession is not a minor credibility footnote. It is the prosecution's entire rebuttal to the defense theory that Pino was sober, embedded inside a question that sounded almost casual on its face. Florida Statute 327.35 requires the state to prove that the operator of a vessel was under the influence of alcohol to the extent that his normal faculties were impaired, and that this impairment was the proximate cause, the legally direct cause, of the victim's death. Proximate cause means not merely that the operator was present and the accident occurred, but that the impairment itself was the operative factor that made the crash happen. Under Florida Standard Jury Instruction 28.130, the jury must find that the death would not have occurred but for the defendant's impaired operation. This is the legal threshold the cross-examination was built to attack. If no witness observed Pino drinking, if no witness observed impaired behavior, and if the witnesses who might have noticed were admittedly buzzed and focused entirely on each other rather than on the defendant, then the foundation of the state's impairment case rests on inference rather than observation. That is the legal question the cross-examination was designed to expose.
All right?
Yes.
Okay. And obviously, at this party, you weren't there to hang out with the defendant and his wife. You were there to hang out with your friends and the other boys that were there. Fair to say?
Yes.
So you weren't keeping an eye on everything that the defendant, George Pino, was doing, were you?
No.
And you've known him for a long time, correct?
Yes.
And you had faith and trust that he'd be able to safely take you and your friends back to Ocean Reef for the party that was going to be that night, right?
Yes.
And because you had trust in him, you weren't turning around and looking to be like, oh my God.
She was at seat 12, facing the back of the boat. Defense attorney Adams walked her through it methodically. To see what was ahead of the boat from seat 12, you'd have to turn around, right? Yes. But you weren't doing that, were you? No, because you trusted Mr. Pino to get you back safely.
Yes.
You weren't monitoring what he was doing. No. He wasn't your focus. Your friends were. Yes. Now, the second witness, Natalia Reed, Brown University, management consulting internship, also buzzed by her own admission, 2 or 3 seltzers, also not watching George Pino, also there for her friends, not for him. Did this boat ride feel different from other rides you'd taken with Mr. Pino? No. Was anyone standing up before the crash? No. Was anyone sitting on the gunnel, the railing? No. Did Mr. Pino seem impaired to you? No.
Consuming alcohol that day at the sandbar?
Yes.
Do you know how many drinks you had?
I remember having 2 or 3. I don't remember feeling impaired or intoxicated.
And when you were at the sandbar, did you see Mr. Pino with any kind of alcoholic drink in his hand?
No, I did not see that.
And were you mostly spending time with your friends there?
Yes.
Okay. And when you were...
Not a clean concession. She stopped short, and that hesitation mattered, because the first witness said yes. Buzzed people are not reliable judges of another person's impairment. And the second witness refused to say the same thing. 2 witnesses, same question, 2 different answers. The jury heard both. Nobody was watching George Pino drink. Nobody was watching George Pino's behavior. Both witnesses trusted him because they had always trusted him. And both witnesses, by their own account, were focused on each other, not on the man operating the vessel carrying their lives. Here is what that means in the real world. If the prosecution cannot place a drink in George Pino's hand, cannot identify a single witness who observed impaired behavior, and cannot establish through testimony that his normal faculties were compromised, and if the only evidence of potential impairment is the fact that alcohol was present on the boat and that some passengers were buzzed, then the proximate cause element of Florida Statute 327-35 becomes a significant vulnerability. In a felony boating manslaughter case, reasonable doubt does not require the jury to believe Pino was sober. It only requires that they cannot conclude beyond reasonable doubt that his impairment caused Luciana Fernandez's death. Reasonable doubt is a constitutional right. It is the reason the standard exists. A competent prosecution in this case was obligated to do several things it may not have fully accomplished before the defense witnesses took the stand. Under Florida Rule of Criminal Procedure 3.220, the state was required to disclose all witness statements and to prepare its theory of impairment with specificity. Not just the presence of alcohol, but documented evidence of the defendant's consumption, observed behavioral indicators, and a toxicology result if one was obtained. The state's cross-examination strategy of conceding impaired judgment from witnesses who were themselves buzzed was legally sound, but it also raised an implicit question the state never fully answered: if the witnesses were too impaired to assess Pino's sobriety, how reliable is their testimony that he seemed fine? That cuts both ways. A properly prepared case would have neutralized that double edge before trial. The reasonable doubt standard, established under In re Winship 397 U.S. 358 1970, requires the prosecution to prove every element beyond a reasonable doubt. The impairment element here is exactly where that burden is most exposed. The human cost of that exposure belongs to two people: Luciana Fernandez's family, who needed the state's case to be airtight, and George Pino, who faces a felony conviction on a foundation that two of the closest eyewitnesses have now partially undermined. The accountability mechanism for a prosecution that files felony charges without securing sufficient direct evidence of the key element, impairment, is, in most Florida jurisdictions, a verdict of not guilty, nothing more. Most people believe that if someone dies in a boating accident and alcohol was present, the operator is automatically criminally liable. That is not what Florida law requires. Florida Statute 327.35 does not punish the presence of alcohol. It punishes impaired operation that proximately causes death. The difference between those two things, alcohol present versus impairment proven, is the difference between a tragedy and a felony conviction. The cross-examination in this case was built entirely around that gap, and it is a gap that the state's own witnesses, by admitting their buzzed state and their inattention to the defendant, helped make wider. The jury's job now is to decide whether the gap is wide enough to reach reasonable doubt. The prosecution's closing argument will rest on the totality: alcohol supplied to underage girls by the defendant, a fatal crash on a clear day on flat water, a 17-year-old girl dead.
Okay. Now, on the day that you all were having this party, it was to celebrate his daughter Ceci's upcoming 18th birthday, right?
Yes.
None of you guys were 21 yet at that point, right?
No.
But Mr. and Mrs. Pino had provided in a cooler drinks, including alcoholic drinks, that you all wound up drinking that afternoon, right?
There was seltzers in the cooler, yes.
And those seltzers had alcohol in them,
Yes.
right? And there was some beer in there too?
Yes.
Okay. And the Pinos didn't say, hey, girls.
The state will argue that the only explanation consistent with these facts is impaired operation. A responsible, unimpaired operator on a clear day on calm water does not crash a vessel and kill a passenger. The crash itself, the prosecution will argue, is evidence of the impairment. The defense will counter with the witnesses themselves. Not one person on that boat observed George Pino drink. Not one person observed impaired behavior. The boat ride felt normal. The speed felt normal. The weather was clear. The water was flat. Accidents happen on the water for reasons that have nothing to do with alcohol. Mechanical failure, navigation error, an object in the water, a moment of inattention that does not rise to criminal impairment. The defense will argue that the state's entire impairment case is built on circumstantial inference, not direct evidence, and that the Constitution requires more than inference to strip a man of his freedom and his reputation. The one question neither attorney has fully resolved before the jury deliberates: if every witness who was positioned to observe the defendant's behavior was, by her own admission, either buzzed herself or focused entirely on her friends rather than on him, is there sufficient independent evidence of impairment to sustain a felony conviction beyond a reasonable doubt? What this case establishes is not a question about boating, it is a question about evidence. A felony conviction requires proof, not probability, not inference, not the tragedy of an outcome. George Pino faces the possibility of losing years of his life, his reputation, and his freedom based on what a jury believes happened on a boat in waters where the people best positioned to observe him were, by their own words, not watching. Luciana Fernandez's family deserves a verdict built on the full weight of admissible evidence, not on the emotional gravity of their loss alone. The measure of justice is not whether we feel someone should be convicted. It is whether the evidence proves they must be. The next video examines a case where the prosecution's toxicology evidence was introduced without the expert who collected it, and the chain of custody standard that determines whether such evidence can legally be used against the defendant is one of the most misunderstood procedural safeguards in American criminal law. Was the prosecution's decision to rely on witness perception of sobriety from passengers who were themselves buzzed and focused on each other rather than on the defendant a reasonable evidentiary strategy given the absence of a toxicology result, or did it represent a fundamental failure to secure the direct evidence of impairment that a felony boating manslaughter conviction constitutionally requires? And if it was a failure, does Luciana Fernandez's family deserve a higher standard of case preparation before a charge of this magnitude is brought to trial?